Dear audience, you are welcome Divan podcast. I'm Anna Prihodko, PhD International Law. Today, we are pleased to welcome Professor Borys Babin, a Ukrainian scholar, public figure and politician. He is a Doctor of Laws, professor, and an ad hoc expert for the Organization for Security and Cooperation in Europe, the Council of Europe, and Military Rights Group International. Professor Babin is well known for his work in international law, human rights, and protection of the Crimean Tatar people. Professor Babin, you're welcome to our podcast. It's a pleasure to have you with us today. Okay, my first question is about you're a well-known expert on Indigenous people's rights. Could you tell our audience about your experience and your work in protecting the rights of the Crimean Tatar people?
Well, the story started 30 years ago when I was a scholar. I was born in Crimea, and from first years of my youth, I was in the situation where all around reminded us about Crimean Tatars on the peninsula who were deported before in Soviet times and were resettling to their homeland after 50 years of absence. And it was an extremely specific situation. It was interesting for a person, for a lawyer, for a politician, and of course the research of the collective rights of Crimean Tatar people was a topic that was not too welcome for public discussion, was not too welcome for scientific research. That's why I decided to start, and from the 2021, when my first steps were done in the academician field regarding these issues, I met a strong support of Crimean Tatar activists from different NGOs and Majlis members of the time that cooperated with me, and I'm grateful to them for the knowledge and the experience they already had in areas of protecting the indigenous rights, not only in the fields of Crimea lands, on Ukrainian or post-Soviet jurisdiction, but also on the international platforms. My first visits to United Nations, to Organization of Security and Cooperation in Europe and others started 20 years ago with strong support of that activists, including the Foundation of the Research and Support of Indigenous Peoples of Crimea, that was the time supported by Majlis, and I got extremely specific experience because I seen by own eyes the strong link and genuine connection between Crimean Tatars and other indigenous peoples. Meetings held in Geneva, in Vienna, in Bucharest, in other places, connected with cooperation and exchanges of minds, exchanges of ideas, and elaborating the drafts of international acts. Let me remind the key and milestone document regarding the indigenous right is the Declaration on the Right of Indigenous Peoples, adopted in 2007. And 2 years I was a small visionary maybe, or participant of the process of elaborating and discussion of those norms and provisions, and Crimean Tatars were the recognized part of this process as they were agreed as the indigenous by the caucus of indigenous people of the world. It was extremely interesting experience to have communication with indigenous groups from various continents, race, cultures, and I may stress that among Muslim people and among Turk people, Crimean Tatars was just one of the most qualifiedly presented group. Crimean Tatar lawyers and activists since the end of last century was active on the field of United Nations bodies and presented their ideas of the next provisions regarding the international defense of Crimean Tatar peoples. Of course, there was a lot of communication. It was a strong counteraction from some countries, that are not welcome in indigenous right, including Russia. And from that time, it was obviously for indigenous groups that some imperialistic states are strongly against their collective rights. But of course, I was deep in Crimean Tatar activities, culture, and social policies, not only in the international platform, but also in Crimea, starting from the human defense companies like Azatlik and others, and also in the peaceful reminding on the issues of indigenous far before Ukraine recognized the declaration and the legal status of Crimean Tatars. For example, before the occupation, every year Crimea hosted Day of Indigenous Peoples of the World, adopted by the United Nations, and I participated in celebration of these days in Bakhchisarai, Yevpatoria, Sudak, Simferopol. A lot of indigenous representatives from various states visited Crimea and exchanged their experience in protecting their collective rights, in their cultural tradition and tolerance and multiculturalism. It was a unique story that should be remembered.
As we know, the legal status of the Crimean Tatar people in Ukraine has developed greatly over the last 35 years. What do you consider the most important milestones in this process?
Well, this process was started in the end of the Soviet era, when Crimean Tatars are settled to their homeland. And after the documents that stressed that deportation was a legal act and confirmed the collective rights of deported peoples, Ukraine restored the Crimean autonomy. It was in 1991, and this restoration was a mirror to the collective rights of Crimean Tatar people who established this autonomy in 1921, but alas, as Crimean Tatars were numerous but minority in their own homeland since 1991, their participation in the issues of political and social life for a long time was marginalized, and collective of pro-Russian politicians and propaganda was strongly against any mentions about collective right of Crimean Tatars. But in 1992, for example, even in the Republican bodies of the Republic of Crimea of the time, they were adopted some norms, not about Crimean Tatars, but for example for other indigenous peoples as Karaites and Krimchaks, that recognized their indigenous status and collective rights. It was something like first step that allowed Crimean Tatars to develop the policies of protecting their collective rights, and the next step was adopting the Ukrainian constitution in 1996. This constitution established that indigenous peoples have collective rights in Ukraine that should be guaranteed by law. But next 15 years was spent to discussions, sometimes very far away from reality, about what are indigenous people regarding Ukrainian constitution. Is this legal mechanism a part of international standards, or it's something unique and Ukrainian one? And alas, a lot of post-Soviet academicians and politicians rejected any mentioning about Crimean Tatars in this stage. And this gray zone on law, this situation that when collective rights of Crimean Tatars were not recognized, allowed various groups and politicians, including some Crimean Tatar politicians, play games without legal binding instruments, and, we may stress, a lot of persons liked this situation. Maybe that was a ground that until Russia invaded and occupied Crimea in 2014, the law about the indigenous people was not amended. And the discussion were, for decades, first of all about quotas of Crimean Tatars in the Ukrainian parliament and in the Crimean Supreme Council or Verkhovna Rada of the Crimea. But these discussions were reflected only in some acts like President Kuchma period, when Majlis of Crimean Tatar people, as a body that we learn later about its statute and regime, was recognized as the Council of Representatives of Crimean Tatar people before the President of Ukraine. And on the stage of Kuchma's time, Majlis members were incorporated in this council, and management of this council activities was delegated to the representative office of president in the Autonomous Republic of Crimea, and it acted in such role before till the Russian occupation. But when Yanukovych came president, situation was changed a bit, and this council was changed by personality from the members of Majlis. For other Crimean Tatars, they were loyal to authorities of Yanukovych time, and of course it created a situation when Majlis acted separately and Crimean Tatars in this council were not members of Majlis, as minimum as a part of them. And last time Kurultai, the national gathering of Crimean Tatar people, elected the Majlis in 2013, a year before Russian occupation, and from up to that moment there were no any close perspective to see the changes in the protecting the collective rights. And a lot of politicians were satisfied by the situation. Let's be honestly, there were not even public discussion on this issue except the academicians. But when Russia started this unprovoked aggression and attempted annexation of Crimea in 2014, Ukraine recognized the regime of indigenous peoples for Crimean Tatars and recognized the status of Majlis and Kurultai of Crimean Tatar people by the provisions of the Ukrainian parliament. But even in 2014, the law about indigenous peoples was not adopted in Ukraine. But Ukraine adopted the law on rehabilitation or restoration, the right of deported persons. Of course, it was not the same, but a lot of scientists, managers, and politicians before 2014 often mixed two situations: aid to former deported persons and their ancestors, and collective rights of Crimean Tatars. And if collective rights were not recognized more or less in Ukraine, the aid to deported persons was a part of state policy. There was relevant budget programs, relevant funding, and the system of bodies, including the Republican bodies in Crimea and some institutions of Ukraine. And only after some years of occupation of Crimea, a year before broad-scale aggression against whole Ukraine, Verkhovna Rada, Ukrainian parliament, adopted the law of indigenous people. It was a strong step forwards, and of course this adoption grounded on provisions of these drafts and ideas we proposed for years before, including the backstage of OSCE and UN platforms, and of course adoption of this law was a milestone for protecting the indigenous rights in Ukraine.
As we know, Russia aggression against Ukraine started 2014, and the further occupation of Crimea have created serious challenges for the Crimean Tatar people. How would you describe the current situation of Crimean Tatars in their historic homeland?
Well, the situation of Russian aggression and attempted annexation developed in some frameworks, including Kremlin's propaganda regime, including establishing the illegal administrative mechanisms in peninsula, and of course establishing a repression system. For the first months of occupation, Kremlin tried to play with Crimean Tatars as he often did before with other groups in controlled territory, promising them some preferences, but this situation was not long, and still some months of occupation, the persons who were Majlis members or others who came into collaboration with the occupying bodies, who became the so-called vice prime ministers or so-called heads of district administration, were changed to other persons. And till the end of 2014, it was obvious that Kremlin will not recognize and will never agree with the collective right of Crimean Tatars. From the first days of occupation, Crimean Tatars' civil movement was strongly against Russian occupation, and finally Majlis of Crimean Tatar peoples also came to same position and rejected the so-called occupational authorities and occupational administration. It caused the legal ban of Majlis of Crimean Tatar people that was finalized by Russians in 2016, and Russian repressions against Crimean Tatars started from the first day of occupation, including tortures, enforced disappearances, arrests, raids, and others, and now we may calculate about some hundreds of Crimean Tatar hostages in the Russians' place of non-freedom. And speaking about the situation that developed from this partial aggression to broad-scale aggression in 2022, we may stress that in the mainland occupied territories where Crimean Tatars resided also, including Zaporizhia and Kherson region, the level of repression that started there from the end of the February 2022 against Crimean Tatars was even heavier and more brutal than in Peninsula itself. At the same time, Russian occupiers tried to form the useful, for them, Crimean Tatar collaborators and use them as muppets for the global or regional propaganda project of Russian intelligence, or for manipulation in third countries, including Turkey. But we may stress after the 12 years occupation that these attempts ended by nothing. The key example was, for example, the destiny of Ruslan Balbek, who was declared by the occupiers as so-called Duma deputy, and who was formed as so-called face of the Crimean Tatar collaborators in the first years of occupation, and he was often guest to not only in the Russian TV, but sometimes in the international platform. And for example, I do remember in the end of 2019, when Russians transferred him to UN office in Geneva to make a speech that was blocked by the collective position of the civil society representatives and indigenous representatives that day, but it was maybe one of the final attempts to galvanize the issues of Crimean Tatar collaboration on the broad-scale level. Later, when Russia started broad-scale aggression against Ukraine, Crimean Tatar collaborators in Crimea were marginalized even less, as the regime, let it name so, was in absence of any possibility of solving any issues except of some corruption schemes and being a face in the propaganda movies. Attempts of aggressor to create something like councils from the Crimean Tatar collaborators and to show them to the world society as a so-called change of Majlis as a representative body ended by nothing. Of course, till this day, some propaganda steps are made by Russians, including the so-called visits of Crimean Tatar collaborators to Turkey or Uzbekistan, but these are only the imitation of activities, and the persons who are used by Russians in so-called project of cooperation did not reflect the position neither of Crimean Tatar people, even not of some more or less numerous Crimean Tatar groups. It is a situation till this day, but we may stress that in future the attempts of Russians to use Crimean Tatar collaborators as a tool for communication with Muslim countries and Turk countries will be continued till the deoccupation of Crimea.
All right. Since the occupation of Crimea, several international legal processes have focused on protecting the rights of Crimean Tatar people. Could you explain the main results of these efforts and their future prospects?
From the first months of the occupation of Crimea, activities of Crimean Tatars on international platform was to show the real face of Russian imperialism and to prove that so-called referendums, so-called voting, and so-called reunion of Crimea with Russia was totally fake. For example, I was present in such communications in Geneva offices in the May or June of 2014, when the first systematic analyses were presented to United Nations bodies and reflected in the first documents that stressed the illegality of occupation, that stressed the presence of broad-scale violation of human rights law and humanitarian law in Russia-occupied Crimea. Also, Ukrainian state started to be a part of these processes, and from 2014 the lawsuits against Russia were initiated by the Ukrainian government, and I participated in it also, as in 2015 I was an agent of the government before the European Court on Human Rights, and this lawsuit covered the issues of Russian occupation of Crimea and later of the areas of Donetsk and Lugansk region. Alas, the situation of communication with international bodies and level of elaborating of the position in such case sometimes, of course, was not too effective on that period. First of all, because of nobody understood the mechanisms and perspectives of such activities, but we may stress that after 10 years, in 2024, European Court on Human Rights finally adopted a judgment regarding these applications and established a broad-scale violation not only the personal human rights of some victims, but also broad-scale and systematic repression of Crimean Tatar people by the Russian punitive structures as the administrative policy establishing that a discrimination of ethnic Ukrainians and Crimean Tatars in Crimea was not an accidental steps of some local persons, but was a part of Russian governmental policies. And these activities contrasted in international body, in the European Court of Human Rights, more or less contrasted with situation of the proceedings in the International Court of Justice that Ukraine initiated regarding the Convention of Protecting Against Racial Discrimination. This case was started in 2015, as you remember. It was convened by the Ukrainian Minister of Foreign Affairs, and it ended in 2023, and alas, International Court of Justice did not found the violation Ukraine described in its application against Crimean Tatars. Only established violation was a discrimination of Ukrainians, ethnic Ukrainians in the Crimean school. It happened due to some reasons. First of all, it was caused by the negligence of some of the officials in collecting evidences and in absence of systematic and programmatic approach in this case. And the decision of International Court of Justice now is actively used by Russian propaganda as alleged proof of alleged absence of violation of international standards in Crimea. So the tool of European Court of Human Rights allowed us to block this provocation. As I do remind you, it adopted its judgment on the interstate case in 2024, and later, till the 2025, European Court on Human Rights started to establish judgments on the lawsuits of individuals, including Crimean Tatars, who were the victims of Russian repressions. Up to this day, we have some cases adopted by the European Court in its judgments, including Bekirov and others against Russia and others, it covers only some groups of violations, including violations of peaceful assembly and violation of freedom of belief. For example, it was on the application of some Crimean Tatars priests, Muslim priests, and on some activists that protested against the repressions, trying to have peaceful rallies or meetings. But also other cases are still pending in the International Court on Human Rights. I also assisted a group of Crimean Tatars, and the milestone of this case is the group of Mejlis case. Let me remind you that Mejlis was banned by Russia legally in 2016, and after this ban, a group of lawyers and activists made a huge work passing the stages in so-called Russian jurisdiction to form the position before the European Court on Human Rights, and applications were sent to Strasbourg as from Mejlis as a body, so from Mejlis members, members of local Mejlises, of other Kurultai bodies like of Counting Commission, Revisional Commission, and others. And this group of cases that have approximately 30 applications now is, I may stress, on the final stage of proceedings in the European Court on Human Rights, and we communicated on this issue till 2025 with the European Court. Most dramatic part of these proceedings was, for example, the case of local Mejlises of Kherson region that I do represent in Strasbourg, in some villages of Kherson regions where local Crimean Tatars community resided on Ukraine-controlled territory till 2022, preserved the part of system of Mejlis, of local Mejlises, and even before the broad-scale aggression, they passed lawsuits to Strasbourg describing that repressions and imperialistic policy of Russia in Crimea have directly influence on them also, and they wrote on this application 5, even 7 years before the broad-scale aggression, that they're afraid that Russians came not only to Crimea but to Kherson also, and will cover the punitive policies and will repress them also. It happened in 2022, and when European Court on Human Rights returned to this case after 3 years of occupation of Ukraine's mainland in this area, we also collected evidences. We collected new data about new victims of repression, and that allowed me to stress that on the Ukraine's mainland, the issues of repressions against Crimean Tatar people was extremely brutal, and it is a dark and not too discussed page of this story of Russian imperialism.
In April 2026, Ukraine officially recognized the legal status of the Mejlis of the Crimean Tatar people. Could you please explain the reason for this decision and its importance for the future of the Crimea, and especially the Crimean Tatar people?
Well, Mejlis was elected by Kurultai in 1991 and declared itself as a representative body of the Crimean Tatar people. A Ukrainian state did not recognize this body de jure as a representative body till 2014, but de facto, as I stressed before, Ukrainian authorities communicated with this body, and this communication sometimes was not public, sometimes it was not regulated by law, and else, we may stress, sometimes it satisfied all parties of this communication. But when Russian aggression started, Ukraine made declaration about recognition of Mejlis, but after this declaration in 2014, next steps were done only 7 years later. And even contrary to attempts of some officials, I also tried to galvanize these processes when I was a representative of president before the Autonomous Republic of Crimea in 17, 18 years. this issue was solved later. But when this law was adopted, it established a special procedure of recognition of the representative body of the Crimea of the indigenous peoples, and this proceeding was administrative one. It must be done on the sub-legal level by the decision of Ukrainian government and authorized bodies such as Ukrainian state service on the freedom of conscience and ethnic issues. And in 2022, the special proceeding was adopted by Ukrainian government that established a framework who and how should pass the appeal before the government of Ukraine for adoption of a special act for recognition in next the legal regime of the representative body of the indigenous peoples. The Majlis activists, Majlis members, initiated this issue in 2023 before the head of Majlis, and I must stress it as a lawyer who helped them to collect documents and helped them to transfer the documents to the state service. We understood, such some Majlis members and some civil activists, that we should do these proceedings as nobody will understand us if the Majlis will be silent in situation when the legal framework for its legalization was established by Ukraine. These documents were passed to the state service in the summer of 2023, and nothing happened a year after. In this situation, in the autumn of 2024, Majlis members whom I did cooperate on these issues and whom I gave legal aid for the preparation of this document decided to pass a lawsuit to Ukrainian Administrative Court in Kyiv against the Ukrainian government. The only purpose of this lawsuit was to fix that Majlis members, as minimum, some of them, do not agree with gray zone covering Majlis, including issues of funding, of activities, of responsibility, and others, and this situation should be reflected in the legal binding documents, if not governmentally issued, but adopted by the court mechanisms. These processes caused a strong turbulence in Ukrainian politics, and we do know that a lot of persons were directly against the persons who started this proceeding and against me as a lawyer that helped them. But anyway, some years after this spring, finally, government of Ukraine adopted the decision and legalized the Majlis. Of course, it was not an easy way. In parallel to the national court proceeding, it was a huge lobbying campaign regarding the duty of Ukraine to finalize this proceedings. There was some discussions on the international organizations, including the Committee on Elimination of Racial Discrimination, that reflected in the May of 2025 the duty of Ukraine to finalize this proceeding in the legal binding concluding observations. It was a big work that was finalized, and now we have the decision that fixed the situation, and next steps, as we, the person in Majlis who initiated it, and I as lawyer that supported this process, that we are fully satisfied. Maybe some next steps regarding the further implementation of Majlis regime in legal framework of Ukraine, including issues of legal entity statute, budgetary funding, including regarding adopting the budget proceedings and budget programs, property issues, and others will be solved, I hope, in next. But we decided, I and my colleagues in Majlis, that we do not participate in it further, as This situation demands a collective position of all Majlis, and it had, and we hope that we'll make relevant steps in future in cooperation with Ukrainian governing bodies.
In your opinion, Dr. Babin, what are the main priorities and next steps for the Crimean Tatar national movement, both in Ukraine, including the occupied territories, and among Crimean Tatar communities abroad, especially in Turkey?
Well, the situation after the legalization of Majlis should be developed. The legalization of Majlis that we achieved was not a tool for new bonuses or privileges or state awards for those members of Majlis that are in Kyiv now. They already had all of them. This legalization faces the future. This legalization foresees a situation when the Crimea will be deoccupied and Russia, and we know that it will happen, will stop the illegal regime of imperialistic pressure. And the first steps to be done in the deoccupied Crimea should include the elections of new Kurultai, and this Kurultai should elect new Majlis regarding the democratic proceedings that were in force regarding the Crimean Tatar community that were established by the Crimean Tatar people itself before 2014. This is the main goal of Majlis legalization, to fix the duty of international society to recognize the collective rights of Crimean Tatars to elect new Majlis in the occupied Crimea, and respectively the right of the Crimean Tatars itself to make exactly new Majlis adopted by new Kurultai elected by the democratic proceedings. It is a key challenge in modern world. You may see a lot of countries does not change the leaders for decades, including the Turkey, including other countries. And this gerontocracy that happens not only in Turk states but in others, including some states we named democratic before, should be stopped one day. New generations of persons who live in Crimea regarding Crimean Tatars should face their rights and voice after the deoccupation in situation of freedom, in situation of absence of fear, absence of repression, and establish a new bodies that should be a voice of Crimean Tatar people. Let me remind that Majlis was elected in 2013 last times. It was not a guilty of Crimean Tatar people. Crimean Tatar people could not and cannot re-elect Majlis for last 13 years. It is a long story. But we are sure that this re-election will be done. What should we do now before the deoccupation? My advice to Crimean Tatars is, first of all, to preserve their subjectivity, to preserve their voice, to keep their national heritage, including language, tradition, and culture, and wait for the occupation, and of course to support us, the Ukraine, including the armed forces of Ukraine, and support all civilized nations that allow us to struggle against Russian aggression. In this situation, civil activities of Crimean Tatars in European countries should be supported. Of course, the specific of Turkish situation in modern conditions limit me in public proposals. We see the current situation with Turkish opposition parties. I am not Turkish citizen, I am not Turkish politician, but of course we may evaluate it, and we must remember that Crimean Tatars that live in Turkey, and approximately 1 million of them are Turkish citizens, is a political power that reflects the will of part of Turkish nation. In this situation, we are well aware of interests of Turkish politics regarding the Crimean Tatar factor. We are well aware about the Russian attempts to influence in this situation. That's why Crimean Tatar people in Turkey, I sure, will show us its wisdom and its strength and its sustainable steps supporting democracy in Turkey, supporting democracy in Ukraine, and supporting democracy between Crimean Tatars themselves. The democracy and human rights and freedoms as a part of our common fight against imperialism and dictatorship. And Crimean Tatars, as in Soviet, so in post-Soviet period, showed to the world that exactly their will to struggle against enemies in condition of democratic proceedings, in conditions of public campaigns, in condition of civil activities, as a strong power that may be the most important in next years. As I am well aware, next years will be a years of struggle for Crimea.
Dear Professor Babin, thank you very much for joining us today and sharing your thoughts and ideas. Dear audience, thank you so much for your kind attention.
Thank you.